Afternoon and welcome. My name is Amy Weismann. I'm the Assistant Director at the University of Iowa Center for Human Rights. And today I'm very pleased to present to you a distinguished panel of experts who will discuss LGBTQ rights at the US Supreme Court. Before we get started, however, I'd like to share a bit of information about upcoming programs through the Center for Human Rights. Next week, on July 8th, at 4 p.m. Central, we will host DACA and the US Supreme Court, a reprieve for dreamers, but a closing of other paths. What does US immigration policy look like today? And then join us for our continuing series, Racial Equity and Human Rights, on July 15th at noon, on police, prosecutors, and race. And on July 27th at noon, on race and international human rights. These programs and all the educational outreach of the UICHR depend on donor support. Please consider giving and visit our website for more information and to do so. Now it's my great honor to introduce our three speakers today. Professor Pat Cain, who is Professor of Law at the Santa Clara University School of Law, and also UI Law Professor Emerita, Professor Arthur Leonard, Robert F. Wagner, Professor of Labor and Employment Law at New York Law School, and Professor Jean Love, also Professor at the Santa Clara University Law School of Law, and UI Professor Emerita. These three eminent scholars will be discussing some very important recent decisions by the US Supreme Court that has impacted the rights of gay and lesbian and transgender and questioning and queer people in the United States. It also has implications worldwide potentially. So without further ado, I want to turn the program over to Professor Pat Cain, who will be facilitating some discussion amongst herself and her colleagues.
Thank you, Amy. And hello to all the participants. Good morning from California. Good afternoon for those of you in the Midwest or further east. I'm delighted to be on this panel. It should be a cozy chat. Art Leonard, who some people have called the father of gay rights in the United States because he writes so consistently on it. And I have the privilege of being his co-author on a book, Sexuality Law. And then my partner in law and in life, Jean Love, who is a constitutional law expert and teaches these issues bravely, I should say, in her con law classes. So today we're going to be looking at a recent decision by the US Supreme Court. The case is called Bostock against Clayton County. That's from Georgia, my home state. And it actually is a combination of three cases, not only the Georgia case, but one from New York and one from Michigan. The Georgia and New York cases involved gay men who had been fired because they say solely because of their sexual orientation. And the Michigan case involves a trans woman who says the only reason she was fired was because she was a transsexual. So they bring a claim, a discrimination claim, and their claim is under Title VII of the 1964 Civil Rights Act, which bans discrimination against private employers on the basis of sex. It doesn't include specifically sexual orientation or gender identity. There have been legislative attempts to add that language to Title VII or to enact a separate bill dealing with that, which have never come to fruition. So the question in all three of these cases is whether or not it is possible to construe the word because of sex to include discrimination on the basis of sexual orientation and gender identity. And the Supreme Court decided, surprisingly to some of us, but not all of us, in a 6-3 decision written by Justice Gorsuch, that indeed Title VII did ban discrimination on the basis of sexual orientation and gender identity. Wow, so it's a very, very important decision. And I'm going to play moderator. That means I have to know enough to ask the questions, but not necessarily enough to answer them. And so I'm going to direct my first question to my colleague, Art Leonard, since he's our resident expert in employment law and deals with Title VII quite a bit. So Art, did this decision surprise you in any way? Did it surprise you that it's a 6-3 with Justice Roberts and Gorsuch joining the 4 liberal justices to make it a 6-3 decision, and that Justice Gorsuch was the one who wrote the opinion? What are your thoughts about this?
Well, as I sat there on June 15th at 10 a.m. Eastern Time, refreshing the Supreme Court website to see if this opinion would come up, I didn't know how it would be decided. I knew it was possible that the court would rule for the plaintiffs below, who it was possible it would rule for the employers. But I did watch or listen to the audio version of the oral argument, which was held on October 8th, and I read the transcript. In fact, this is the wonderful thing with the Supreme Court website. You can download the transcript and follow along as you listen to the question and answer. It's a great way to really get into the guts of a Supreme Court argument. And I was surprised, very surprised, pleasantly surprised, that both Justice Gorsuch and Chief Justice Roberts, during the oral argument, had seemed to be at least intrigued at the idea that it was a plausible interpretation of the language of Title VII that discrimination against someone because they are gay or transgender is discriminating against them because of their sex. That is, that sex plays a role somehow. The question is that enough to satisfy Title VII, that discriminating against someone because they are gay or trans calls their sex into question? Their sex is being taken account of in some sense by the employer when they're making this decision. And that turned very much, in the view of Justice Gorsuch, on the idea that there can be several factors going into a personnel decision, a decision whether to hire someone, whether to fire someone, whether to promote someone. And as long as sex was one of those factors, then the statute comes into play. It doesn't have to be the sole factor. It doesn't even have to be the primary factor. He said, as long as they're taking sex into account in some sense and making the decision, that's something Title VII says you can't do unless, and he didn't add the unless in his opinion, although it certainly came up in Justice Alito's dissenting opinion, unless sex is a bona fide occupational qualification. Congress, when it passed Title VII, said we can't imagine any situation where race or color would be a bona fide qualification for a job. But the other categories, sex and national origin and religion, we can think that there are times when those characteristics might be a bona fide qualification. So they created this affirmative defense for employers. And since the court's ruling in this case goes under the sex category, then the bona fide occupational qualification defense could come into a play in an appropriate case. But I shouldn't have been as surprised as I was when the opinion came out, because it seems that a transgender lawyer here in New York wrote a law review article that was published in the University of California Online Law Review and was actually highlighted in the March issue of my newsletter, Lesbian and Gay Law Notes, in which he critiqued the oral argument in the Harris Funeral Home case, which is the transgender case from Michigan. And he said he thought that the attorney should have focused more on a textualist approach to the statute, and how on its face, if you discriminate against someone because they're transitioning from one sex to another, how is that not discriminating because of their sex? How is that not taking their sex into account? And so this attorney argued that's the argument that they should have pushed. And it might particularly appeal to Justice Gorsuch because he's such a strong textualist. He focuses on what the text says, not on what the legislators might have intended back in 1964.
Can I jump in? I just want to respond to one thing you said and maybe bring Jean into this conversation, because you talked about the kind of causation issue under Title VII. I mean, Jean, you teach torts, which has a lot to do with causation. You know, did the defendant's actions cause the harm to the plaintiff? And while it's true under Title VII that a motivating factor should be enough to trigger the protections, some of us read Justice Gorsuch's opinion as using a much narrower, almost but-for test of causation. How did you read the causation? And I don't know, does it really matter since a looser test, a motivating factor is looser than but-for causation, could be applied in any case?
Okay, great range of questions. First of all, the but-for test is the classic standard test of causation in tort law. And the competing test, the more recent test, is called a substantial factor test of causation. To give you my bottom lines before I elaborate, I read Justice Gorsuch's opinion in the Bostock case as pronouncing that he is using the but-for test of causation under Title VII, but he stretches the definition of the but-for test. He makes it so elastic that for all practical purposes, he has truly adopted the substantial factor test. Now turning to Title VII language, the test that Gorsuch literally applied under Title VII is Title VII's but-for test of causation. The test that he said he didn't have to apply was a test called the motivating factor test of causation. So you can see we have two categories of tests floating around now in our universe. In one stack, we have the tort but-for test, which is mirrored by Gorsuch in what he calls the Title VII but-for test. Then on the other hand, we have in torts a substantial factor test, and under Title VII, we have a motivating factor test. Both Art and Pat are correct that Gorsuch vehemently said, by my lights, that he was utilizing the but-for test of causation under Title VII, and he specifically rejected any notion that he was using the motivating factor test of causation under Title VII. Why? I think because there's much controversy about the desirability of that test. And all Congress has to do is amend Title VII and that test will disappear. That's exactly how it got added into Title VII late in life, and it could just as easily disappear tomorrow by congressional action. So that's all I'm going to say right now, unless you want me to keep going, Pat. I'm mindful that I don't.
That's fine. We got lots of topics to cover. Art, did you have anything to add to that briefly?
Yeah, I mean, Justice Gorsuch does say he's using a but-for test, but then he talks about multiple factors contributing to a decision. And
that's what I want to talk about.
Right, and that it would be, you know, sometimes there's one thing alone that causes a decision. And I'm sure the employers in these cases might all say the thing that caused this decision was because the person was gay or the person was trans. But Gorsuch then breaks that down and says, if you ask someone to define homosexuality or transgender status without reference to someone's sex, they couldn't do it. And therefore, sex is involved. Sex is one of the causes of the but-for causation. But now that the court has adopted this view, it really doesn't matter too much, because the bottom line for the court is if an employer fires someone because they're gay or perceived to be gay, they're firing them at least in part because of their sex. Their sex has something to do with it. Title VII is involved. Let's go on to the other aspects. And this is something that I think needs to be stressed, because, you know, people read the newspaper headlines, and I don't think many people get below the headlines. Lawyers and people who are interested in the law get below the headlines into the body. But the point is that proving discrimination under Title VII, proving discrimination under Title VII is difficult. The pleading requirements are difficult. Lots of people run into court to sue for discrimination without a lawyer and don't know what you have to say in a complaint in the way of factual allegations to actually make a claim that a court will allow to proceed. So, you know, people shouldn't jump over their skis here and go running into court. It's not rocket science, but it has its complexities. There are statutes of limitations. There are procedural steps that you have to take. If you're suing under Title VII, you have to first file a charge with an administrative agency, and give them an opportunity to investigate. And you have to get an authorization from the agency, sometimes called a right to sue letter. And then you have a very short period of time after you get that letter to file a lawsuit. So there are complications, and there are also federal pleading requirements that you have to make factual allegations in your complaint that would ground a plausible claim of discrimination under the developed case law. So there's a lot of work to do. And when I read a lot of court opinions, because I do a newsletter on LGBT law, so I try to read every new case that comes out. And a lot of cases are brought by people on their own behalf without any legal advice, and they get thrown out on a motion to dismiss the case by the employer without the employer even having to make any kind of explanation of why they were fired or why they weren't hired.
Okay,
So, caution to people.
I want to change subjects just a little bit because we want to save time for Q&A at the end. And Jean, I'm going to call on you next. So if you really want to add something to that, fine. But what I want to switch now is to the fact that, remember, this is a case just about Title VII. It rules that the word sex in Title VII includes sexual orientation and gender identity. And I think there's a lot of interesting questions about how far we can carry that. Does it affect other areas of the law? And Jean, the question I'm going to ask you, and then I'm going to turn to Art for statutory references. But since you, Jean, teach con law, there is this status under the 14th Amendment, the Equal Protection Clause of the Constitution, that says discrimination on the basis of sex by a state actor, not by a private employer, is quasi-suspect. Now, those of you who are not lawyers may not recognize that term, but it means that discrimination on the basis of certain statuses, race and sex being two of them, will be looked at much more closely by the Supreme Court and will have to be subject to a much higher justification by the state for imposing that discrimination. So it's good to have discrimination on the basis of sex. If it includes sexual orientation and gender identity, it means they get heightened scrutiny and should win more cases that are equal protection cases. We right now don't know, because of the Supreme Court precedent so far, we don't know what level of scrutiny is applicable to gender identity and sexual orientation. So does this opinion give us a basis to argue that under the 14th Amendment, these categories, sexual orientation and gender identity, will also be subject to heightened scrutiny? Jean, what's your first cut on that?
My first cut on that is yes.
Good.
Very simple. And I'm tempted to get back to causation, but I'll say more about the con law issues. I do have a hypo for causation if we ever have time. The Constitution has been interpreted by the Supreme Court to say that sex is a classification that is between race on the one hand and under constitutional law, sexual orientation on the other hand. So the Supreme Court thus far has made a distinction between race, sex, and sexual orientation. Race gets the strictest scrutiny, then comes sex, and then sexual orientation, well, it's a mixed bag. The beauty of the Bostock case, in Gorsuch's opinion, is that it provides a springboard, not just a basis, but a springboard, leaping us into the proposition that the phrase sex, as it has been used under the Equal Protection Clause, encompasses male and female, as well as transgender, as well as lesbians, as well as gay men, as well as bisexuals. And if that were true, if all those people are lumped together under the single term sex, then right now, without a doubt, and because of Ruth Bader Ginsburg and her litigation in the 70s, that classification is subject to intermediate level scrutiny. And because of Ruth Bader Ginsburg, now that she's a US Supreme Court Justice, intermediate level scrutiny has been pushed as close to strict scrutiny as she can possibly get it, so that race-based classifications are stricken, yes, for sure. And the reality is sex-based classifications are stricken, yes, also for sure. And if Gorsuch's reasoning is brought into the Constitution, then sex-based classifications regarding males and females and sex-based classifications regarding LGBT people and T people will all be subject to intermediate level scrutiny, which is almost strict scrutiny. Now, here's fantasy land. I just woke up this morning to a newspaper article saying that there is now a move afoot in the courts to get a ruling that the proposed constitutional amendment that would guarantee equal protection for men and women should be deemed adopted as of now. And if
You're talking about the ERA. I think
I'm
most
talking
people.
about the ERA, thank you, sorry. I'm talking about the ERA. If the ERA is adopted now, the further thrust of this or gist of this motion is to have the court rule that the ERA requires strict scrutiny for sex-based classifications. If that were to happen sometime within the next week, month, year, we could all wake up and discover that strict scrutiny is applicable to race, sex, meaning male, female, sex, meaning LGBT, sex, meaning T. Wow. I'll stop right there.
Yeah,
And we should add, for those who aren't con law scholars, to know what
Right.
the significance of that heightened scrutiny is, or strict scrutiny. Under strict scrutiny, the challenged policy, which discriminates on the basis of what they call a suspect classification, like race, is presumed to be unconstitutional. The entire burden on justifying it goes to the government, and the government has to show there's a compelling interest that can only be achieved by this challenged policy. So it would be very difficult to sustain and express discrimination of some sort on the basis of sexual orientation or gender identity if this idea is embraced. It really makes the burden on the plaintiff much less. All they have to show is that the policy discriminates. Now, for equal protection purposes, the court says they have to show it's intentional discrimination. And this is where Title VII comes in and provides even more protection in some sense, because Title VII even applies to inadvertent or unintentional discrimination. They call it the disparate impact theory. So if an employer has a policy that puts a greater burden on men than women, even though the policy itself on its face doesn't discriminate based on sex, it could still violate Title VII, but not the Constitution, unless you can show that the policy was deliberately adopted to create that disparate impact. Then the 14th Amendment Equal Protection Clause may come into play. And we should also mention the Fifth Amendment has an equal protection component of equal strength that applies to federal policies. The 14th Amendment applies to state policies.
right. Interesting.
But then we should also mention the one big limitation of this Title VII ruling, and that is when Congress passed Title VII, very aware of the limitations on their power under the Commerce Clause of the Constitution, they can't regulate purely local activity. There has to be some connection to interstate commerce, and they decided only to apply Title VII if an employer has at least 15 employees.
Right.
They said smaller employers not covered by Title VII. The number is right there in the statute.
Let me ask you this, Art. So I was going to ask you about other federal statutes, but now that you've brought this up, there are a lot of states, about half the states have state statutes that protect against discrimination specifically on the basis of sexual orientation and gender identity, and they tend to apply more broadly to even smaller employers. But half the states don't have that. But most of those states, I think all of those states actually, have a statute that bans discrimination against smaller employers, for smaller employers on the basis of sex. So
Right.
Can we take the federal statute, the ruling by Gorsuch, and apply that to a state statute and say under the state statute, the court should construe the word sex to include sexual orientation and gender identity?
Well, here we have two different concepts about legal precedent that come into play. One is something that's called a persuasive precedent. That is, a state court interpreting their state statute may take a look at Justice Gorsuch's opinion and say, I find that to be a very persuasive analysis of what the phrase discrimination because of an individual's sex means. And so I'm going to use that interpretation in interpreting my state statute. The Supreme Court's interpretation of Title VII is not binding on the state courts, because the Supreme Court can't make binding interpretations of state law. But it can be persuasive if they're persuaded by the reasoning. But there is another factor that comes into play, because most of the states, in passing their civil rights law, borrowed the language of Title VII. So the language is almost identical. And so in many states, the state courts have held that they will look to Title VII case law, Title VII decisions in interpreting their statutes. And in fact, within a week of the Bostock decision coming out, I saw a new decision from the Ohio State Court of Appeals. Ohio is one of those states that doesn't ban sexual orientation or gender identity discrimination expressly in their statute. The Court of Appeals decision, a lesbian who was suing for discrimination, she tried to bring in, she argued gender stereotyping and all these kinds of theories that courts have somehow accepted as sex discrimination claims. But the court said, well, after the Bostock decision, our state Supreme Court has said that we follow Title VII interpretations in interpreting, so she could have a sexual orientation claim under the Ohio statute, even though it doesn't mention sexual orientation because it mentions sex. But the court said in this particular case, the factual allegations of her complaint don't suffice to state a valid claim of discrimination.
No.
But so this isn't a holding by the court. It's what are called by lawyers dicta. It's just words, but it's words by an appeals court saying that this is how we're going to handle this in the future. That in Ohio now, there is a good argument under the Ohio Supreme Court's established process of following Title VII precedents of coverage under the Ohio State anti-discrimination law. Now, there was already a decision, I believe, a year or two ago by the Missouri Supreme Court in which they adopted a reading of their sex discrimination provision to cover gender identity claims. And we have had advisory rulings by the civil rights agencies, the administrative agencies who interpret and administer the state anti-discrimination laws in Pennsylvania and in Michigan, in both cases saying that they would cover sexual orientation and gender identity. And that, of course, will have to be tested out in the state courts unless the legislatures in those states amend their statutes to add sexual orientation. So the point here is that this opinion in Bostock can be very influential and maybe even seen as binding in many of the states that don't presently address sexual orientation or gender identity directly. So,
and Art, surely it also can be used to interpret other federal statutes.
Oh yes,
especially something like the Fair Housing Act, which has always been interpreted pretty much the same as Title VII. But there are other federal statutes as well. So,
yes.
How broad is the federal reach of this ruling?
Oh.
Sex includes.
Here we look to Justice Alito's dissenting opinion. One of the arguments that Justice Alito was making was that faulting the majority of the court and Justice Gorsuch for not taking account of the impact that this decision would have throughout the federal code of statutes. And these days, it's easy to do this with the computer. You can put together a list. So he attached to his dissenting opinion as an appendix a list of all the federal statutory provisions that in some way have some relationship to sex discrimination. And he counted more than 100, which is amazing to me. I can't sit down and imagine that many. But it seems that throughout the federal code, there are provisions in which someone's sex is taken into account in some way. But the ones that are most in the forefront of litigation are the Fair Housing Act, of course, which prohibits sex discrimination in the provision of rental or sale of housing. And it applies, I believe, both to commercial and residential housing. And we have the Equal Credit Opportunity Act, which forbids discrimination on the basis of sex by banks, financial institutions. We have Title IX of the Education Amendments Act, which says that no one shall be deprived of equal access to educational opportunity on the basis of sex by any educational institution that receives federal financial assistance. Well, virtually every public education institution in the United States receives some form of federal financial assistance. So right there, we're going to see under the Equal Credit Opportunity Act. Now, under the Affordable Care Act, which may or may not exist after next term of the Supreme Court because there's a challenge to its constitutionality pending before the Supreme Court, but the Affordable Care Act has an anti-discrimination provision with respect to health care and insurance. And that incorporates by reference anti-discrimination provisions from other federal statutes. And one of them that it incorporates is Title IX of the Education Amendments Act, which forbids sex discrimination. So arguably, under the Affordable Care Act. Health insurance companies and doctors and hospitals and other healthcare institutions may not discriminate against people on the basis of sex, which means now on the basis of sexual orientation or gender identity. And this was very timely because just days before this opinion came out, the Trump administration announced a new regulation withdrawing protection for transgender people under the Affordable Care Act, which it seems they can't do because you can't overrule a statute with a regulation. Statutes under our division of powers in our federal code, statutes take priority over regulations. So you can't adopt a regulation that directly contradicts a statute. And so if the sex discrimination provision in Title IX is interpreted consistent with the Bostock case, then the Affordable Care Act will have a consistent interpretation, and the courts will declare the Trump administration regulation to be invalid. And there are various other areas in the federal government where the Trump administration has moved to try to change rules that had been adopted by the Obama administration involving sexual orientation and gender identity. And many of those will now come to grief when challenged in the courts if this interpretation is followed.
And one other thing, we discussed this briefly when we met the other day. Do you see any possible international consequences from this U.S. Supreme Court decision?
Well, the U.S. Supreme Court's opinions are read with interest by courts in other countries, especially in countries that follow the British common law as their original source of jurisprudence when they became independent and no longer colonies. Canada, the Canadian Supreme Court looks at the U.S. Supreme Court decisions. The South Africa Supreme Court has leaned heavily on U.S. Supreme Court decisions in developing a jurisprudence under their post-apartheid constitution. The highest courts in Australia, New Zealand, any country that follows the numerous British colonies around the world have frequently looked to U.S. Supreme Court decisions. So although a U.S. Supreme Court decision is not binding, obviously, on any foreign court, the chances are good that it will have an influence. Certainly, American court decisions had a big influence on the Supreme Court of India when it declared their sodomy law unconstitutional a few years ago. They cited and quoted from U.S. Supreme Court rulings. So what the Supreme Court does have an influence.
Okay, there's one other topic I want to consider briefly before we move to Q&A, if it can be considered briefly. And that's this growing stress on freedom of religion, which we have some fears about how far the current Supreme Court is going to go in protecting that. They just issued a recent decision in favor of religion, but I don't see that it has a lot of bearing on the question I'm asking, which is whether or not individuals or businesses can claim that they have a religious exception under Title VII. Now, I know under Title VII there is a specific religious exemption. I mean, a church can hire employees that, you know, for its religious purposes that are the same religion. That's basically what was intended by that. It's been construed fairly narrowly, but we're seeing a growing number of cases around the country, some of them about to hit the Supreme Court again, where employers are claiming that they have a religious right to discriminate under Title VII or a state public accommodations act. And they're claiming that it's their religious liberty. What sort of issues or possibilities do you, I mean, I'm not asking you to come to conclusions, just to speculate because it's still early in this, but do either of you have about this?
Well, it was certainly mentioned by the court in the Bostock case. Justice Gorsuch, in passing, referred to the Religious Freedom Restoration Act, for example. The Religious Freedom Restoration Act.
That only applies to the federal government. So how did that come up?
The way this came up is that the Religious Freedom Restoration Act has been interpreted to prevent the federal government from placing an undue burden on an individual's practice of religion. And in the Hobby Lobby case several years ago, the Supreme Court said that a business could raise a defense under the Religious Freedom Restoration Act, that not only individuals, not only people, because the federal code, in fact, defines businesses, corporations as people. for purposes of federal law. So there is always the possibility that someone will try to raise a Religious Freedom Restoration Act defense in a Title VII case on the theory that when a federal court is enforcing Title VII, it is acting as part of the federal government. Now, the various federal circuit courts of appeals take differing approaches to this. And here it's worth talking very briefly about some of the background in the Harris Funeral Homes case, EEOC versus Harris Funeral Homes, which was one of the three cases that was melded together for the Bostock opinion. That was the case involving a transgender woman named Amy Stevens, who was a funeral director for Harris Funeral Homes, which has several funeral homes in the suburbs of Detroit, and had been hired as a man, was identified as a man at birth, but struggled with her gender identity for many years and finally decided it's time for me to transition. And she sent a letter, which she struggled over composing this letter. She wanted to write it just right. She gave it to her boss, and 2 weeks later, he fired her. He said, this isn't going to work out. Can't have this. And when he was challenged on this in the EEOC, the Equal Employment Opportunity Commission, where she filed her Title VII claim of sex discrimination, he said, it's inconsistent with my religious beliefs. I have strong religious beliefs. My funeral homes are my calling. I am called by God to do this work of comforting the mourners and conducting a dignified funeral, and I don't think I can do that with a transgender funeral director who he thought of as a man in drag. He said, my customers would be, they'd be distracted, the whole business would be undefined, et cetera. So he tried to raise a religious defense. And in fact, the law firm that volunteered to represent him when the case went to court was Alliance Defending Freedom, which is a sort of right-wing anti-gay religious advocacy group. And they raised this argument for him. They said that under the Religious Freedom Restoration Act, if the EEOC is going to sue him, which they decided to do, Amy Stevens didn't file this case. The Equal Employment Opportunity Commission filed on her behalf. If the government is going to sue him here, he has a right to raise the Religious Freedom Restoration Act and say that they have to show they have a compelling interest that can only be achieved by forcing him to employ a transgender funeral director. And the federal district court, the trial court in the case, agreed with Alliance Defending Freedom. The court said that under the rules in the Sixth Circuit, which includes Michigan, under the rules in the Sixth Circuit, a gender identity claim under Title VII could be a valid claim on a theory of sex stereotyping. But I have to grant judgment here to the funeral home because they have a valid defense under the Religious Freedom Restoration Act. And the EEOC appealed that to the Sixth Circuit Court of Appeals, which reversed the Religious Freedom Restoration Act issue, but agreed with the trial court that if you put the Religious Freedom Restoration Act out of the picture, then under Title VII, Amy Stevens should win. And so then it was the funeral home that appealed to the US Supreme Court, but for some reason, which I don't understand, they didn't raise the Religious Freedom Restoration Act issue in their petition to the US Supreme Court to hear the case. And so the case was only granted review on the Title VII question. And as Justice Gorsuch says, none of the employers before us are now raising the Religious Freedom Restoration Act. But he said, in an appropriate case, it's possible that it would provide a defense. Now, in the Sixth Circuit, it only provides a defense if the EEOC brings the case. If the individual brings the case, that's not seen as the government enforcing the statute. That's seen as the individual enforcing the statute. So the Sixth Circuit would say the Religious Freedom Restoration Act is not involved. But the circuits are in disagreement about this. Some circuits say it doesn't matter who the plaintiff is. If they're enforcing a federal law, that's asking the government to impose a burden on the defendant's religion. So the Religious Freedom Restoration Act is a wild card here. We don't know how it will play out. In the Hobby Lobby case, writing for the court, Justice Alito said that he couldn't imagine that someone could defend a race discrimination case under Title VII by raising the Religious Freedom Restoration Act. And in her dissenting opinion in that case, Justice Ginsburg said, but what about sexual orientation claims? You know, we don't have a question, but she raised that as an issue. So this is one of the areas that we have to see how this is going to play out. Will there be many employers who are sued under Title VII for sexual orientation or gender identity discrimination who try to make Religious Freedom Restoration Act claims? And how will the court handle those? We don't know yet, but it's one of those questions that's sort of hanging out there.
Yes. Okay, we're going to break in a minute for Q&A, but Jean, did you want to add anything to that?
I do. Just yesterday, the Supreme Court handed down a religion case. I'm not going into the details of that case. Suffice it to say it's from Montana. And Chief Justice Roberts wrote the opinion. He ruled in favor of a broad interpretation of the religion clauses, and he reached for the issue. The state Supreme Court had set the case up so that the Chief Justice didn't have to write an opinion at all. The court didn't have to decide the case at all, for reasons that I won't go into here. But what this tells you, or what this tells me, is that the court is really eager to take religion clause cases, whether it be under the Free Exercise Clause or the Establishment Clause. And it is worthy of noting that we have 5 Catholics on the court right now, and the 5 Catholics split 4-1 in the Montana case. So
we should add that there are 2 more cases that were argued to the Supreme Court this term that haven't been announced yet on the issue of the ministerial exemption.
Right.
The provision exempting religious organizations under Title VII in the statute only exempts them from the ban on discrimination because of religion. But the Supreme Court has expanded that on a constitutional basis by saying it would violate the Free Exercise Clause for the government to dictate anything to a religious organization about their personnel policies regarding ministers or people who are hired to carry out religious functions on behalf of the organization. They should be able to discriminate on any ground they want. They should have total free reign. Otherwise, it would violate the First Amendment. And that's what these 2 cases are about. These are both cases involving teachers at religious schools who have claims of discrimination on some other ground. I think one is a disability case and one may be an age case. And the question is whether they're ministerial employees. And these are people who are teaching in religious schools, but they're not teaching religion. I think one's a math teacher, something like that. Should the ministerial exemption get a broad interpretation? And that's what we're concerned about, because if there's a broad interpretation, there are a lot of cases around the country of employees of religious organizations who are gay, who are known to be gay, who no one had any problem with it until they married their same-sex partners after the Obergefell decision. And then all of a sudden they get fired. And so some of them are suing under Title VII or analogous state sex discrimination laws or sexual orientation discrimination laws, and the religious organizations are saying ministerial exemption. Mm-hmm. So how far that ministerial exemption applies is an important issue for a fair number of LGBT people who are employed by religious organizations.
Okay, we're getting some questions. I'm going to throw a couple out. One person wants us to talk more about the impact the ruling will have on Title IX in the higher education context, especially thinking about the rescinded Dear Colleague letter. And I'll just add to that, the burning question under Title IX that's kind of exited from the courts recently is the use of bathrooms.
Oh, that question's still there. There are bathroom cases all over the place. In fact, there are bathroom cases and counter bathroom cases because at the beginning, the cases were transgender students suing for the right to use a restroom. Mm-hmm. And now there were school districts, some of them in response to that famous Dear Colleague letter from 2016 that the Obama administration sent out to all the school districts around the country. Some of them adopted policies saying, yes, transgender students can use the facilities consistent with their gender identity. And then there were lawsuits filed by parents and students who were opposed to that policy, claiming it violates the Title IX rights of them, and it violates the parental rights of the parents to govern the upbringing of their children, and that people are going to suffer great trauma when they go into a restroom and they are casually exposed to the genitals of a member of the opposite sex or something like that. And this is more of an issue in high schools in junior high schools than it is in colleges and universities, because under the prevailing standards, you can't do gender confirmation surgery until you're an adult.
Right.
The WPATH world standards for transgender healthcare say that a person has to be at least 18 years old. So that means, as a practical matter, when you're talking about transgender students in high schools and junior high schools, especially transgender women, they're transgender women who still have male genitals. And so parents express outrage that their little girls are going to be exposed to the male anatomy in the restroom or the locker room. And so far, the courts have not been particularly receptive to the parents' arguments. But this is a question that's being litigated in enough places that it's likely to end up before the Supreme Court at some time, which will be very interesting to see the Supreme Court devote an hour or so to oral argument about restrooms and locker rooms.
Yeah, you know,
New topic for them.
I've used women's restrooms all my life, and I've never been exposed to anyone's genitalia.
Yeah, it seems to me, now men's rooms with urinals, I could see that's more of a problem.
Right.
But a transgender man is, if we're talking about high schools, a transgender man is going to use a stall.
Right.
They're not going to use a
You're not going
urinal
to have an option.
because they do not have the anatomy to use a urinal.
Right.
Okay.
Okay, now we talked about Title VII and discrimination on the basis of sex, and we didn't really specifically cover the fact that discrimination on the basis of sex also includes harassment on the basis of sex. And so someone wants to know whether what would be considered harassment based on sex, and how do you prove it? I mean, we have the on-call case, of course, already decided by the Supreme Court that says the gender of the person doesn't matter. If it's harassment, it's harassment. Not a lot of analysis in that case, but it certainly stands for the proposition that same-sex harassment is covered as well as opposite-sex harassment. But here, I assume the question is about harassment on the basis of sexual orientation or on the basis of gender identity. So do we see any interesting issues there?
Well, I think you know,
Can I just jump in?
Go ahead. Go ahead.
Thank you. I listened to an earlier presentation by Kai Feldman, and I want to just use her hypo, but with Pat and me as the example, and then use it as a springboard to sexual harassment. If I'm sitting in my office and I have a photograph of Pat on my desk, because she is not just my partner, she is my legal spouse, I'm proud to say. And if my heterosexual female best friend is in the next door office and she has a picture of her husband, Pat, on her desk, I can get fired for, prior to Bostic, I could get fired for having a picture of Pat on my desk, she's my spouse, but my best friend could not get fired for having her picture of her husband, Pat, on her desk. Okay, if Bostic has done what we think it has done, if Bostic now makes it possible for both my best friend and for me to proceed with a cause of action under Title VII on the theory that I have been fired because of my sex, then take the next step. If a woman is being harassed by a man, she obviously can sue under Title VII. If a man is being harassed by a woman, he can be sued under Title VII. If a gay man is being harassed by a man, he can sue under Title VII because Justice Scalia said so. Now, what have we got in this new world order? I think that if there's harassment on the basis of opposite sex attraction, same sex attraction, it doesn't really matter. I think if a transgender person is harassing a non-transgender person, that's sexual harassment. I just don't see how Gorsuch's opinion can be read any more narrowly because of what? Because of that very broad definition of causation that he gave in the opinion in Bostock that I haven't had a chance to talk about, but that's okay. We won't talk about that today.
Although, you know, one of the aspects of the Oncology decision, which is the same-sex harassment opinion written by Justice Scalia, he said, there's nothing in Title VII that says that a man may not sexually harass a man, but the plaintiff is going to have to prove that they were harassed because of their sex. All right, there's the phrase, because of their sex.
That's because of, and
Under
that's the
Bostock,
conviction
that
issue.
could include because of their sexual orientation or gender identity.
Of course
I
it
would
does.
think.
After Bostock, that's the very
After
point that
Bostock.
I was wanting to make
Right.
earlier.
Right,
I
but
think
now
there's
it's very
absolutely
clear.
no
But
doubt
there's
about it. Of course, it's just writing the opinion.
But there's another aspect of it that's very interesting, and I've seen some speculation about this on the Bloomberg BNA Daily Labor Report. There was a follow-up article, and someone said, well, this will resolve the problem of the equal opportunity harasser cases. That is, under Title VII, the theory has been a workplace bully who only harasses men or who only harasses women violates Title VII because of sex discrimination. Because Title VII is not an anti-harassment statute, it's a sex discrimination statute, so the harassment has to be discriminatory in some way. So many courts have said someone who harasses everybody without regard to what their sex is can't be in violation of Title VII because they're not a discriminatory harasser. They're an equal opportunity harasser. Well, not anymore. Not anymore. If it's harassment of a sexual nature, if it focuses on the person's sex in some way, even if they're harassing both men and women, I would think under this opinion, it doesn't matter what the gender is. You add the Oncology case to this, and I think equal opportunity harassers are out of luck under Title VII.
I agree.
Well, that's interesting. I mean, Kitty McKinnon, when she first wrote about harassment of working women, did raise the phenomenon or the quandary, I guess, of the equal opportunity harasser, the bisexual, who equally harasses both men and women. And I think there's some people, I think Nancy Polikoff actually raised this issue in a recent webinar that we were listening to. Is it clear that bisexual discrimination is covered under the Gorsuch opinion?
I would think so. Because how can you describe bisexuality without reference to sex?
That's right.
Right? And that's part of his test.
That's it.
He comes up with various hypos and examples to explain his reasoning. And one of them, he says, you ask someone to explain to someone who doesn't know what homosexuality or transgender status are, and they can't do it without reference to sex. Well, I would say the same is true of bisexuality.
That's
The
right.
court never mentions bisexuality anywhere in the opinion.
No.
And some people have complained. They said, well, this doesn't protect bisexuals. I said, sure, it protects bisexuals.
So,
Okay, I have one quick question for Art. Someone wants to know, is the trans attorney that you were mentioning, was that by Chase Strangio?
No, that was Ezra Young.
Okay, we know that.
He's
Now,
an attorney in New York.
Other people want to know what resources they might recommend to increase legal literacy for those without a law background. We did post some resources in the materials for this. We didn't expect anyone to really read them all before class, just like my students don't always read everything they're supposed to before class. But you might take a look at that. Now, some of them are directed at lawyers, but they're mostly web posts through SCOTUS blog.
Yeah, but there's a book that I would recommend called Rainbow Rights.
Yeah.
Right,
Okay.
Pat?
If it's still in print, it's from the year 2000, and it gives the whole history of the struggle for gay rights from 1950 to the year 2000. And I think it's pretty good, but I'm biased since I'm the author. In any rate, you might look at, and then Art, has his blog, and there's a post to Art's blog in those resources as well. And, I think Art writes plainly enough that non-lawyers can get a lot of it. He publishes a monthly newsletter, Law Notes, Gay and Lesbian Law Notes.
Well, now it's called LGBT Law Notes, because
LGBT,
we have so much, in fact, transgender, this is something to point out to people. This is the first real substantive decision by the US Supreme Court in its history about transgender rights. There was a case way back in the 1980s, Farmer versus Brennan, about the rights of transgender prisoners to be protected by the prison against attacks by other prisoners. But this one is the first anti-discrimination provision, a case to be decided by the Supreme Court. But transgender rights have just been exploding in the courts over the last few years. And as far as my newsletter, LGBT Law Notes, goes, it is archived on the New York Law School website. and anyone can go there and can download a copy. They're in PDF file form, so they can be easily downloaded. I also write on LGBT legal issues for a publication here in New York called Gay City News, which is a gay community newspaper, and they have a website. And so I usually have an article in almost every issue. If you want to keep up with the latest important decisions, I'm right there.
He's your man. That's
Your
right.
man.
One quick final question before we wrap up here. Hi, Lynn Sandler. I read your question, and he wonders whether we have a decision, and it's pretty clear about what it covers. Do you expect more information from, let's say, the EEOC or other guidance, informal guidance, to explain more the reach of this decision?
I would expect the EEOC website will have something eventually. I think the chairperson of the EEOC issued a statement a few days ago about the opinion. The interesting thing is the EEOC, it's a 5-member commission, and obviously the membership changes over time. Every year, one of the commissioners' 5-year terms expires, and the president nominates and the Senate confirms. And so we're far enough into the Trump administration that they now have a Republican majority on the EEOC, but they haven't backed down from their position on these issues. And in fact, when the Solicitor General participated in this case and on behalf of the Trump administration advocated against the employees in favor of the employers, the EEOC, usually the EEOC's general counsel or EEOC attorneys would be on that brief, but they weren't. The EEOC stayed aloof. And Amy Stevens, in the one case where the EEOC was a party, where the EEOC actually filed the case, Amy Stevens intervened as a co-respondent to the Supreme Court and in the Sixth Circuit. And so the ACLU actually represented her in the oral argument. So the government changed sides in that case.
Yeah. And actually it was her wife, because Amy Stevens unfortunately died before she won
But
her.
at the oral argument, and she was present at the oral argument.
Yeah.
So at least she got to see that. Unfortunately, she passed away a few weeks before the opinion came out.
Yeah.
Are there any other questions? I see we're right up at our time.
I think that we're at our ending time. Amy, should I turn the presentation back over to you to close us down?
Sure, Pat. Thank you so much to all of you for your fascinating and very important insights. I'll direct everyone to the University of Iowa Center for Human Rights website for the resource list that Pat referenced, as well as a link to Arthur's blog. And we will also be posting this webinar once it's finalized as a recording on our website to be viewed and shared with others. So please return and do that. And I hope to see you again at our future webinars. Thanks again. Bye-bye.